DEI Coordinator's drunken disaster. Hotel staff stunned by conference room chaos. Blackout drunk at work event. A former DEI coordinator faces Judge McBurney for property damage after urinating in a hotel conference room, leaving staff in utter shock. Fired from his job and grappling with his reckless night spirals into a legal nightmare. Will his personal struggles earn leniency? Or will Judge McBurney deliver a tough verdict? Don't miss the gripping tale of downfall and accountability.
Swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you may lower your hand. Will you state your true and correct legal name?
Ralph George Drabick III.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone in school?
I am 45 years old. I have a master's degree from Michigan State, and I also have a chartered financial analyst, which is equivalent to a second master's degree from the CFI Institute.
Okay, so you are able to read, write, and understand English?
Oh, yes.
Okay. Do you understand that you are charged with the following offenses? Criminal damage to property in the second degree motivated by bias or prejudice, and criminal trespass motivated by bias or prejudice?
I do.
And do you understand that the minimum and maximum for criminal damage to property in the second degree is 1 to 5 years, and for criminal trespass it is up to 12 months?
I do.
Have you reviewed the charges with your attorney, and have they advised you about the potential minimum and maximum for each sentence?
Yes, and he did.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, Attorney Brian Tevis, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss the case with your attorney?
Not now. No.
Are you satisfied with his services?
Yes, absolutely.
Attorney, do you waive formal reading of the indictment?
Yes, I've reviewed with Mr. Drabick. We'll waive a reading.
Okay,
any
and do you-
defects for the
thank you.
purposes of this plea.
Do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 2 years probation and conditioned to special conditions, but the court does not have to accept this recommendation, and the court can sentence you to the maximum on each charge and can run those charges consecutively or one after the other?
I understand.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including federal courts?
I understand.
Do you understand that if you are not a U.S. citizen, a guilty plea conviction will affect your immigration status and will result in deportation just like a conviction at trial would, and that this is true regardless of any advice by your attorney or anyone else?
I am a U.S. citizen, and I do understand.
Thank you. Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to maintain or obtain employment.
Can I have 1 second on that one?
Yes.
It's a general list of things that could be affected. Not saying you can't do those things except for firearms. You definitely can.
Except assuming everything is okay.
It's they tell that to everybody and everybody. Okay, but they're getting could be affected.
Understand.
You notice.
I understand. Thank you.
No problem. Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, you will be guilty of a felony which carries a sentence of 1 to 15 years in prison?
I understand.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
I am.
Have you ever pled nolo contendere or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Thoroughly, yes.
Do you understand that if you violate any of the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes, I understand.
Do you understand that by pleading guilty, I'm going to read a list of rights that you're giving up, and after each one, if you could just say you understand.
Okay.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury,
I understand.
the right to remain silent and not incriminate yourself,
I understand.
the right to confront witnesses against you,
I understand.
the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case,
I understand.
the right to the presumption of innocence,
I understand.
the right to testify on your own behalf and to present other evidence,
I understand.
the right to subpoena witnesses and compel the production of evidence,
I understand.
the right to have the charges against you proved beyond a reasonable doubt,
I understand.
the right to appeal if convicted of these charges after a trial.
I understand.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights above and enter a guilty plea because you are in fact guilty?
Sorry. With respect to, this is kind of a hybrid. We're negotiated on the plea, and I did raise this with Ms. Rutland. We would ask the court to accept only the motivated by bias portion under Alford versus North Carolina. We would admit factually to the damage itself. I can go into more detail as to why we're asking it to be split that way. So if the court wants to hear that now or at any other time, I can explain why we would divide that up. But
Sure. I'll wait so you can present sort of more in a complete way rather than piecemeal. But let me play back what I think I heard. Mr. Drabeck is pleading guilty and admits guilt to criminal damage to property in the second degree, as well as criminal trespass.
That's correct.
Those criminal offenses, he's saying, I did those things, full stop.
Yes.
There are additional allegations about which I suspect I'll hear more from Ms. Rutland, that those criminal acts were motivated by bias, prejudice, et cetera. I'm familiar with the case, but we'll hear about that. That'll be part of the record. And the pushback is, and not in a negative way, is those aren't being admitted to. There's evidence of it, and Mr. Drabeck is, and I'll have a discussion with him, has decided it's in his best interest to plead to the indictment as it's written. The indictment's not being amended, but he is not admitting that there was a racial animus here or a gender animus or a sexual orientation animus, and he'll get to speak his piece as well. But there's not a disagreement that there is a sufficient factual basis for the actual elements of the two crimes, setting aside the bias piece.
That is correct.
Got it. Okay.
And-
Good.
Okay.
You can add anything you want on that front, but I understand where Mr. Tevis is drawing the line.
Okay, great. We
We
do.
had discussed that prior to court as well.
Yes.
Yeah.
Yes. So, do you want me to just finish the plea or would you rather? make it-
You should keep going the way you were going.
Okay. How do you plead to the charges of criminal damage to property in the second degree and criminal trespass in the indictment number 24 SC 005057?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging this guilty plea?
I understand.
Thank you. Okay, if it may please the court, I will give a brief synopsis of the facts. On August 28th, 2024, the Starling Hotel contacted the Atlanta Police Department in reference to a potential hate crime. APD LGBTQ TIA plus liaison Officer Hayes responded to the scene. He met with Ashley Miller, a representative of Global Black Pride, who said the event was set up in the Sequoia room of the hotel with multiple vendors inside. Ms. Miller notified the hotel staff that the room had been vandalized. The items damaged in this incident include mannequins, sound bath bowls, costume designs, pride flags, tables, and trophies. Among the damage was a pride flag that had been defecated on. Officer Hayes then spoke with Denise Brabham, a member of the hotel securities team. She stated that she was informed by 2 security guards about an incident that occurred the night before. She stated that one of the security guards, Mr. Jamarian Roberts, was patrolling the conference room and checking the rear doors when he heard what sounded like someone inside the conference room. He then witnessed a male pulling up his pants and walking towards him. The male was instructed to leave the area. Ms. Brabham then stated that a second security guard was called later that night about an intoxicated male laying down in the lobby of the hotel. The second security guard escorted the man back to his room 709. Ms. Brabham also gave the Officer Hayes an iPhone 14, which was found in the Sequoia conference room with a business card attached to it. The business card belonged to a Mr. Ralph Drabick, who was also the owner of room 709. Officer Hayes then reached out to Mr. Drabick and asked about the events that had occurred. And Mr. Drabick stated that he did not remember what happened, but he was extremely sorry for anything that might have happened. He went on to state that he is not part of the community, but he does not have anything against them. He stated that he would do anything to make it right, but he did not deny any of the allegations. And that all happened in Fulton County.
Where's that? The Starling Hotel.
188 14th Street Northeast. Is it Sterlington? No,
I'm not disagreeing. I never heard of it, whatever it's called.
I think
Starling.
it's
Starling?
Yeah.
So it's on 14th Street.
Yes.
Okay. Okay. Anything you want to, well, I guess you need to tell me more about, you said it's 2 years probation is the state's recommendation, or maybe they
Yes.
negotiated, but you had hinted that there are some special conditions of probation.
Oh, yes, excuse me. The special conditions include restitution to be determined at a later date, to complete sensitivity training, and to provide a written letter of apology to the victims.
So I'm going to talk to Mr. Tevis in a little bit about how probation is going to work given Mr. Drabick's state of residence. I'm assuming the state, meaning your office, doesn't object to Mr. Drabick being supervised out of Pennsylvania, assuming Pennsylvania accepts supervision.
That's correct. No objection there.
Okay. This letter to the victims, how does that work? Who are the victims? Is it an organization to which he would address it, or is there a president of the organization, or how do you see that going?
Yes, it could be to Global Black Pride.
Okay. And that's the organization that had the Sequoia room.
Yes.
I know it was Black Pride weekend, but Global Black Pride rooms at the hotel, and in particular, the Sequoia room was their conference hub.
Right.
Okay. And is that something that Mr. Drabick would get to you and you get it to them? He gets to probation and they figure out how to get to Global Black Pride?
No, it can be provided to me and I will get it to them.
Okay.
Send it to me, I'll send it to her.
Do you have any victim impact statements or information from Global Black Pride or any of their representatives?
I do not. We have spoken with the victims in depth. They are accepting of Mr. Drabick's apology and his apologetic nature that he's expressed throughout this entire thing, and they kind of are understanding of that and ready to move forward.
Okay. All right. This hearing got scheduled on a little bit of short notice, and it doesn't look like we managed to get pretrial services here to run a criminal history.
Okay.
Your visibility may be more Georgia only rather than nationwide, but Ms. Rutland, did you find anything about Mr. Drabick that would make him not eligible for first offender?
No.
Okay. And talk to me a little bit about why 2 years probation as opposed to more. How did you arrive at that?
We arrived at that conclusion of 2 years being appropriate because of Mr. Drabick's we believe that he was sincere and apologetic. We also received a mitigation kind of packet that included, we took into account his problems with potentially alcohol and just his willingness to cooperate and his, dedication to resolving this case. We spoke with the victims who agreed that that would be appropriate, and so that's what we went with.
Okay, so did you get pushback from Global Black Pride of only 2 years probation, not 10 years prison, or?
No, we didn't.
Okay, all right, thank you. Mr. Tevis.
Thank you, Judge. Mr. Drabick had run his own private national background check through a third party. If the court wants that, I have that, but I will state in my place that he has no felony convictions or any significant criminal history, if any. With respect to this case, and the reason that we're asking for this to be kind of a hybridized under Alford, there is no doubt that he was intoxicated, and this conference room at the hotel was locked from the front, but apparently there's a side door, another door that they determined was not locked. And I believe that Mr. Dravick just wandered in there. He has no memory of this. He woke up the next morning with no phone, no wallet. Somebody mailed possessions of his. He has no idea who. They arrived at his home address, and he took them to a lawyer there who opened it, and that was his wallet and some of his items. But he has no memory of anything that night. He was in town at the hotel because his employer had something going on here as well. So they had
And his employer is or was?
Yes, he's been terminated, but at the time, sorry, I'll move that sheet. You can just,
Rabobank.
spell that for me.
RABO and then bank, Rabobank.
Oh, sorry, here it is.
Rabo
Yes,
Diversified.
Rabo Diversified Services. And they were in town. They had a happy hour for the employees that were here. They had dinner, there were cocktails involved. And at some point, Mr. Dravick has no recollection of any of this, but he was found by the hotel to be intoxicated, apparently lying on the floor, and was his phone was found in the conference room. So there's no dispute about the damage, but we don't believe that there's any motivational bias. We believe that it was alcohol intoxication. As the court is aware, and in making an accommodation and moving our last court date, he's been going through like a very serious custody dispute with his ex-wife in Pennsylvania. He is in therapy and meets with a counselor about coping mechanisms and how to deal with these things in a healthier way. That's been ongoing before, during, and after this case. He, in his previous employment, was named as the DEI Coordinator for his office and had put on presentations for 20 or 30 employees about these issues. He shared in those meetings that he himself, being Hispanic, has received derogatory epithets directed at him and how he handled that. He has a member of his family, I believe it's a cousin, who was transitioning from her to him, and his family had some problems with that, and he worked with them to help explain how to approach that and to have those discussions. So he is adamant that there was no hatred or animus based on gender, sexuality, race, any of those things. But there's no denying that he was intoxicated and the damage was caused. That is the reason that we're asking the court to accept the plea. We're negotiating on everything except that one component. And with that component, rather than being kind of a factual certainty, I mean, there's a circumstantial element that, as far as I can see, it's simply that, this was the event that was happening. It's not as if he was attacking somebody or directing any vitriol at them, but the items that were damaged happened to be in that conference room where he stumbled in, and that is where we are today.
So if this had happened this week, it could well have been an NRA flag that he went to the bathroom on.
Yes, Judge, that is the case. It was nothing about that group. And as Ms. Rutland said, from the entirety of this case, he has been extremely apologetic. This is, of course, like humiliating, embarrassing. He lost his job because of this. That was in September. One more thing that we would be asking of the court, the first offender statute does allow a ceiling on the front end. I've prepared an order and I have letters. He has had 2 prospective employers in January and March who said, hey, we're great. We're in this process. We want to extend this offer. The background check came back. You have this open in Fulton County. We can't offer you the job. I also have a letter that is pending right now from 4 days ago that is offering him a position subject to a background check. These are well-paying positions. He's been in finance for a long time. Prior to this job, he was at Wells Fargo for 5 years. Prior to that, he was at Aquin Financial and Ally before that. He's in the banking industry and has been unable to work since the September termination from Rabo Diversified Services. And so we are asking that the first offender be sealed on the front end. I have no doubt there will be no violations. He will complete the terms and the special conditions immediately. And that is another reason that we asked the court and the state, thank you for accommodating us, to move this up from the May date. Mr. Dravick has been pressuring our office to, I need to resolve this as soon as possible. Can we get in? Because he's unemployable while this is pending. And so certainly, in addition to being apologetic and very remorseful and embarrassed by his actions then, I certainly think that there has been enough punishment and reflection on his part that this is, something that would never be repeated, but he still does need to earn a living. And so we're asking the court to seal, pursuant to first offender, the records of arrest and the clerk's records as well. And I've prepared an order if the court is inclined to do that. I don't, in my discussions, I mentioned this with Ms. Rutland, and her response was that she had no objection to first offender. I don't know if you meant with regard to the sealing or not, but so I don't know if we're negotiated on that part, but I have the order.
Okay.
And the letters if the court would like to see them.
How is this going to work with Georgia and Pennsylvania and probation?
I don't think there'll be any issues as far as, he would still be on probation. So typically he would meet with probation. They would get his information. They'll do the transfer to Pennsylvania where he will be supervised. Should there be any violations, of course, he has to come back before this court. But
I didn't ask the question well. My understanding is that Mr. Drabeck may need to be in Georgia for a little while to take care of things with the Department of Community Supervision. I don't know that, and maybe there are exceptions, but I know he has to get the police report and the indictment and $100. There's a set of paperwork that has to be filed, and because Mr. Drabeck is subject to supervision of Georgia probation until the transfer, I don't know that living in Pennsylvania is okay until the transfer happens. We probably can engineer something to make it okay, but it may not be tonight is okay. I thought maybe you, given the pressure you've been receiving from Mr. Drabeck, had already reached out to probation. I'm pointing to Ms. Simpson, not that you would have talked with her, but there are a couple of people who are responsible for ICOTS, one half of the country or the other. No, I think it's actually like A through L and then M through Z. So there is someone in DCS Atlanta who would be letter D, handling the process for your client.
so there's a couple ways. I have had in felony cases even done virtually where probation will meet with them virtually, or that I've also had somebody stay around until 2 o'clock, go to DCS, and they'll do the input for ICOTS at that time, which we can certainly do before he heads back. And also the court can put in the order that he is allowed to leave the state. He would continue to communicate with them and do what he needs to do, but he's not required to stay here. So those are the three ways that I've had it handled before.
Okay.
I've never, and I wasn't aware that we could do probation stuff on the front end before there was a sentence because they haven't input or intake his information. But
Yeah, for future reference, you can. It's not that they're going to say, great, now you're under supervision. Until there's a sentence, there's no supervision. But if you know going into it that this is someone who's going to want to reside out of state, then you can prime the engine, already provide the indictment, the police report, the $100, all that can be ready to go. And so all that's left is here's the final disposition. Right. And then I'd assume there has to be that first intake session, which can happen today. I don't know when Mr. Drabeck was planning on going back, but I would encourage him to have as his next stop going down. It's 3 blocks from here. And you're here, you can help him.
And the indictment.
Yeah. And we can get, Ms. Nelson can get the final disposition done pretty quickly and email that to you so you can then get it to your client. I just am flagging this because we'll get the official word from Ms. Simpson, but it may not be so simple as, hey, sort it out when you're back in Pennsylvania. There may need to be a few boxes that have to be checked before Mr. Drabeck can leave the state. And I'm not suggesting that is a 3-week process, but we just need to make sure we coordinate this.
Okay. Could we put it in the order that he be allowed to return home? He will have to come back to collect the bond money anyway, so it's not a problem to come back if probation needs him. But I think today he drove through the night to get here in the morning and is planning to return because someone's watching his house and his animals. But
okay,
as long as he
we'll talk about
probation,
right? We'll talk about what absolutely has to happen before he goes. And I am comfortable having a condition that he can, while we work through the ICOTS, reside in Pennsylvania. But I just didn't want him to think he could run out the door, hop in his car and drive away.
No. We would meet with probation.
Okay. So Mr. Drabeck, you have not been able to work at all since you were fired, or you've had to work in a job that isn't your preferred job?
I haven't had any work since then. I've 15 years in financial services, and those were the firms that I was reaching out to. Not only banks, but other advisory firms.
Okay, so you've been living off of savings or the goodwill of friends or family?
Savings.
Okay, all right. How long were you the DEI coordinator at your previous job?
6 months.
Had you just gotten it, and then when you were fired, you also were no longer the DEI coordinator?
When I was brought on in March, the person that brought me on asked me if I would do that. Champion was the correct DE&I champion. So
You had only been at this company for 6 months. Got it. Okay. It was a new job for you.
that's right. They recruited me out of Wells Fargo.
Okay. So this was a improved opportunity for you. You were excited, paid more, or it was an advancement to go from Wells Fargo to this job?
I was happy to take the offer.
Okay. Then lose it.
Wasn't happy to lose it.
No. Understood. You are divorced or separated.
Divorced.
Was that driven at all by alcohol-related issues?
No, this was 12 years ago.
Oh, and there's a custody fight now.
My daughter's 12 years old.
Okay, got it.
We divorced before she was born. Or we split, I should say, before she was born.
All right. Is there anything you want to add to what your lawyer shared?
I just want to agree with what Brian was saying and just add to that I'm terribly sorry. I have no recollection, but I have a hole in my heart because of this, and I have a terrible feeling. And even with what Ms. Rutland had said about what I spoke to Mr. Hayes, like I couldn't believe what he was telling me. I was like literally throwing up and being sick. I didn't know if it was me, but what he was saying and everything that was going on, it just, everything about this just makes me sick. So I'm hoping that.
It's a somewhat remarkable event, whether it was a conference room that was, or a large space that had been occupied and festooned by an organization, or if it was just an empty conference room to use it as a restroom and then be awakened from a stupor in the lobby or wherever you were found. That whole process, forget about the potential hate element to it, is somewhat remarkable. That's why I asked a little bit about your divorce. Is this the first time that you have drunk to excess, or is this an issue? And here's why I'm pressing.
I understand.
I want to make sure we've got good conditions of probation in place. Because if something like this happened again and you're still on sentence with me, you'll come all the way back down to Georgia to get locked up, and you'll lose your next job, and you won't have helped your 12-year-old daughter or whoever else is important in your life. So if there is a need for treatment, and Mr. Tevis mentioned that you're getting counseling, I didn't press him on that because it's not his, it's yours. People get counseling because of relationships. People get counseling because of addiction and whatnot. I want to make sure we don't leave untreated something that causes you to do what you did just a few months ago. And not the hate part of it, you can't treat that. But I drank way too much. It was cocktails, it was dinner, it was after dinner cocktails. And you went to the bathroom in a conference room at a hotel on the floor. That's not normal. And you need to not do that again. And that may mean you need help. I want to make sure you get it.
So I've never had an alcohol-related offense, never had a DUI. I don't know what happened that night. I don't know if it was a mix of things. I don't know. I wish I could tell you. I don't know.
Okay.
But it was one night, one incident, and I still don't know. I wish I had a better answer for you, but I'm not going to sit here and make excuses either. All I can tell you is that I enjoy having a beer socially, but I've never taken it that far in my adult years. I was a 20-something. I was a college kid. I did have to learn my limits at a young age.
Right, but we're a couple decades past that.
We are, and that's where I was going with that.
Okay. All right. So you don't think, apart from this unfortunate night that caused a lot of hurt for other people, that there is an underlying substance abuse issue?
No, I do not.
Okay. All right. Do you have any questions about anything Ms. Rutland has said or that I've said?
No question, just the concern about my being able to leave here, to get back to my family.
Okay.
It's the concern. I don't know if it's a question, but it sounds like Brian understands what needs to be done, and I'm comfortable with him and everything he's done so far. So
okay, you're in good hands there, and we're going to hear a little bit from Ms. Simpson, who is with probation. She won't be your probation officer, but she is in the know as to what'll need to happen today, the bare minimum of what needs to happen today or before you can leave. Okay. Ms. Rutland, you mentioned that we may reconvene on the restitution front. I hear that a lot from ADAs, and then we never talk again. Is there something actively in the works on this, or and Mr. Tevis just was anxious to take the plea, and so he's agreed, hey, I'm going to give you the time you need to round out the numbers?
Yes, the representative from Global Black Pride is going and getting an itemized, detailed list of damages for me.
Okay. Do we have a ballpark so that I can have, I mean, it may be that we don't have to have a hearing because there's documentation and the figures are reasonable. But if it's $10 million, then we may be back together again to work through, wait, where did those numbers come from?
The estimation that I have is 8,000 to 10,000. Right?
Okay. All right. But the people you're working with are trying to document that.
Yes.
You'll share what you get with Mr. Tevis, and I'm fine having the hearing. I just, leaving that open, it's a little complicated just where Mr. Drabick will be. But he can always elect to appear virtually for a restitution hearing. That's different from what's happening today. Okay, thank you for that. Mr. Drabick, first offender, I am sure you and Mr. Tevis have talked about it. I need to talk to you about it as well. It is primarily an opportunity that the Georgia Penal Code affords people who haven't been in trouble before, and that describes you. At least you haven't been caught before. You don't have a criminal history that would preclude you from seeking to use the first offender status. The benefit is, the one you'll feel most immediately if I sign the sealing order, is that the arrest, and it's not a conviction today, it's a sentence, but you have a first offender disposition, and that can all be put under seal. And if you successfully complete the term of your sentence, and it's really, that's a twofold use of that word, term as in the length of your sentence, but also the terms of, you do sensitivity training, you write the letter, et cetera. If you do all those things, then not only can things remain sealed, but you can get things expunged. And Mr. Tevis can help you with that. It's a second chance that we give people who are first offenders, and you qualify for that. The downside of first offender, and it's important you understand it, is that if you are a slick talker, but are withholding from your lawyer, most importantly, but from me, there really is an underlying issue, and weekends aren't good for you, and you may well, in the middle of the summer, get pulled over because you drank too much and this and that. You come back down here because there are new charges, then I don't know that I will, although if it's anything like this, I promise you I will, I can take away your first offender status. There'll be a hearing, you'll be represented, but with a pretty low threshold. If the state can convince me that you did this thing on probation that was a violation of the law, then without a trial, because you've already admitted guilt, I can resentence you. And in this case, it would be up to 6 years. Now, you get credit for however much time you had been on probation. But in my example, if we're together again in 6 months, I'd have 5.5 years to work with. And if what you did in 6 months is indicative of recklessness, not taking care of yourself, in any way related to disparaging people on the basis of race, creed, sexual orientation, et cetera, it would be a big chunk of the 5.5 years that I would say, this isn't working. Welcome to the Georgia Department of Corrections.
I understand.
Not a place you want to be. You are not built for that. I say that not to threaten you, other than I'm going to sound like a broken record. My concerns about you and substance abuse, you don't fit the profile of someone who's going to get arrested again. But you need to understand that if I'm reading it wrong, and you are, there are messy repercussions in the first offender situation. Do you understand that?
I understand.
Okay. Understanding the primary benefit of first offender, but the potential risk of first offender, do you want to be sentenced as a first offender?
Yes.
All right. Your offered plea, as I understand it, but I want to hear it from you, is not to the fact that you damaged property, that you defecated in the room, that you're in a room you weren't supposed to be, et cetera. You admit to all those things. You may not remember them, but you're not saying wrong guy or anything like that. Your phone with your business card taped to it in there. You are admitting to all that. You are saying, but I don't agree with the state's contention that those crimes were motivated by hate or bias.
That's how I feel. Yes.
Okay, got it. I will accept your plea in that context. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea. And knowing means that you've understood everything we've discussed. And if you didn't, and I saw you do it a couple times, you took your lawyer aside and had a little back and forth with him. Do you agree with that?
I agree with that.
All right. I'm sentencing you pursuant to the Probation Options Management Act, which in Georgia at least means that if you have a minor probation issue, let's say you missed a meeting with probation, you don't have to come see me. You and probation will work that out. I don't know how that works in Pennsylvania, but if you're in Georgia, that's how that'll work. I will not set any restitution at this time. On count one, which is criminal damage to property in the second degree, I am sentencing you to 3 years of probation. Count two is 12 months of probation. Those will run concurrently with each other, meaning at the same time. Special condition number one is that you complete a sensitivity training course. Number two, that you write a letter of apology to the Global Black Pride organization. You'll get that to Mr. Tevis, he'll get it to Ms. Rutland, and she'll get it to the leadership of Global Black Pride. And then number three, I'm adding, you will submit to a drug and alcohol abuse evaluation. And if that counselor or medical professional recommends any treatment, then that treatment will become part of your probation. I'm extending the probation a little bit longer than what was negotiated because I think it better fits what this case is all about. I'm adding that additional condition just to make sure we're backstopping. Life is complicated. You have had a stressful life over the last few months. And I just want to make sure if one of the ways you manage that stress is to just use anything to excess, that you've got a treatment program in place to protect you and the people you care about. But it may well be that you get that evaluation and they say, other than this horrible misstep, you don't have any issues on that front. And then there's no treatment. You don't need to worry about it, but you'll know you've had an evaluation where an expert in that field has had a chance to take a look at things and say, you have a good self-restraint in this space. Okay. Mr. Tevis, I am open to sealing things. If you could email to Ms. Nelson a Word version of the sealing order, I will take it from there because I understand the state does not oppose sealing things at this time. And it makes sense, Mr. Drabick, if the goal here was to grind you down, then it would be, let's send you to jail. If you're not going to be in jail, you might as well be able to provide for yourself and your daughter and other people who depend on you. You probably could have flipped burgers over the last few months, but you have a skill set that you're not able to rely on right now because these charges are open and a background check displays them. I'll tell you, if you had been charged with stealing from your employer, I wouldn't want anything sealed, even though it's first offender, because I would want the next employer to know, wait a minute, you may not want him in a position of trust. He can clean the floors, but he can't be near the drawer that has the money in it. But that's not your situation. Ms. Rutland, do you have, one more thing. Mr. Tevis, is it all right if someone in my office signs the indictment on your behalf?
Yes.
Can we sign for you, Ms. Rutland? And Mr. Drabeck, instead of handing papers around these days, we e-sign lots of things. Can we electronically affix your name to the indictment indicating your first offender semi-offered plea in this case?
Yes.
All right, we will do just that. Ms. Rutland, did you have anything else?
No.
If you do sort out restitution and it's contested, just let Ms. Nelson know and we'll figure out a day for a hearing. If it is agreed upon, then an email copying Mr. Tevis to Ms. Nelson saying, here's the amount and it's payable to, I'm happy just to amend the sentence. We don't need to drag anyone into court. I'll amend the sentence and that'll become a condition of your probation, Mr. Drabeck, that you pay that restitution. Restitution, unless it's negotiated, is never due immediately. It's pay as you are able. And you may have some debts that you've accumulated over the last few months, but you also are going to be going into an industry where I know you don't make minimum wage. So you'll need to pay that restitution. Another reason to give you a little more time on probation, because you can pay it over time. I don't have an ability to enforce payment once your sentence is done. So that's another reason to, in my mind, extend probation a little bit. So anything else, Mr. Tevis, on your side?
Your question.
Ask you one question. Don't even ask.
And I must have missed this part too. You said you were extending then I heard the alcohol abuse class. Are you extending the time of probation?
I gave him 3 years probation.
Okay.
3 years on the felony, 12 months on the misdemeanor, running them concurrently. So yes, I am extending it.
And his question then is, if he if he pays the money back and does all those things, is there an opportunity to terminate it at the 2 years?
So what I'll do is set a behavioral incentive date of April 26th of 2027. That's 2 years from today. If you've paid
Judge, the sound went out.
Okay. Yep. I just wanted to make sure that it's somebody in a source. Yeah, it's a standard.
Hey, Ms. Rivers, the podium dropped for some reason. Everything else was still on. What was the last thing you heard?
Okay, you said that's 2 years from today, if you've paid, and then it went silent.
Got it. Wow. All right. Sorry about that technical glitch. All I was saying is that if Mr. Drabeck has paid his restitution, everything else has gone smoothly, then I am open to probation, whether it's coming from Pennsylvania or Georgia, petitioning me to close the case out early. But I won't be interested in hearing about that until we've hit the 2 year mark. And then we might have had some pleasantries beyond that, but we don't need to repeat those for the record. Anything else, Mr. Tevis?
I know the court has said you will incline to sign the sealing order, so I don't need to go into that, but just in purpose of the record, I meant to say also that regardless of his record, the GCIC being sealed, the public still has access because, of course, there was a press release. This is in the news. It's on the internet. So there's nothing we can do about that. That may still affect him, but that access for the public's interest is still out there.
Sure. No, a burden you're going to bear forever, Mr. Drabeck, in this day and age, is that there are two background checks employers do. They look at your criminal background check, and then they go to Bing and type in Ralph Drabeck, and lo and behold, there's this thing.
Yep.
And you negotiate that how you negotiate it, but that's not a criminal charge. Is clearly drop dead in your industry if they run your history and there's open charges. That will be sealed. But Mr. Tevis makes a good point. A burden you bear for what you got involved with is that it's still findable. It's just not an open case. So that's where we are. Let's hear from Ms. Simpson because she's going to give you some guidance on the steps you need to take before you leave Georgia on probation.
When you're done, I need your address and contact information. Since, given the timeline that you have given you need to contact Chief Lee today, meaning as soon as you leave here, because there are some steps, just as Jeff stated, that the process that she does before you can leave the state, and you are not permitted to leave before she gets everything that she needs from you. So you need to contact her, and I have her information on your instruction sheet, but you definitely need to contact her before you leave. Because you need to, some things that she needs to get from you in person that need to be handled before you leave the state. Now, in regards to your situation, you can speak with her about it, and she can maybe possibly, I don't know, that's her discretion. But as far as policy wise, you cannot leave until you have through that first initiated process.
Do we know if Chief Woody is in today?
I do not, that's why I said you need to call her.
Okay, well, why don't we, what's her number?
It's 404-985-8784.
Is this her cell phone?
I believe it's her work station.
Okay. Hey, Chief Woody, this is Judge McBurney. How you doing? I'm well. Happy Friday. I am just wrapping up a plea in court with a gentleman who is from Pennsylvania, and he drove down here for his plea. So, of course, you're now front and center. And he and his lawyer are trying to figure out what steps he could take today to get the whole ICOTS ball rolling. Ms. Simpson from your office is in here, and she just let this person know that he needs to connect with you. And I thought, well, let me check with Chief Woody just in case she's not in the office, so we could get sort of directly from her what he needs to do. Hold on one sec. Do you already have the police report?
I have it digitally. I didn't bring a paper copy, but I can print it.
Well, I can print it. I can email you both those things in, well, the final disposition Ms. Nelson's working on right now, but I can email you both those things probably in the next 10 minutes. Mm-hmm. Oh, she knows all that. Yeah, she's told him that. She said that he needed to connect with you today. And if you're at Memorial Drive, you can go down there now. I just didn't, if you're off somewhere else, I didn't want him sort of spinning his wheels. Okay. Who should he, okay, who should he still go down to the office just to sign in and everything? Okay, so I will get you the police report and the final disposition. I'll send you the indictment as well, just so you got all three of those things. And I'll tell him, I'm gonna give you his name in a minute, but I will tell Mr. Drabeck, that's his last name, that he should go down to the probation office. He may need to sit tight for a little bit. He will not see you, but he will get an application that he needs to sign. And doesn't he need to give $100? Okay. Okay. Got it. Okay. That'll be some of the, like his case number or whatever you give him. Okay. So the $64,000 question for him is, when can he drive home to Pennsylvania? And I want to lay this on top. Go ahead. I was going to say, I don't mind if he does that later today, as long as he's taking care of everything you need him to do. Yep. Okay. I'll let him know that. Thank you so much. Have a good weekend. Bye. So you should be able to take care of everything that's essential today and be on your way. I need the police report.
No, that's Ms. Nelson.
Great. I'll take care of the final disposition. That's your sentence. I'll sign that. And I'll also send the email, all three of those, to Chief Woody. I'll copy Mr. Tevis and Ms. Rutland on that email, just so everyone's in the mix. You do need to go down to the probation office. It's about 2 blocks from here on Memorial Drive. And let them know you're here, you're there, to fill out your, would it be called ICOTS? ICOTS, ICOT stuff. Chief Woody is right now reaching, she's not in that office today, but she's reaching out to them to say, oh, I didn't even give, will you give her I was supposed to give her his name. I don't even know what she's going to do now, but you can get that to her. Well, it'll be in the email too. With the email I send her, I will have. Okay. But you'll go down there and say, I'm waiting for this. She's going to send some paperwork in. You'll need to sign a few things that says basically, yep, I know I'm on probation now and I want it transferred to Pennsylvania. And then you should be on your way today. I just don't want you to think that it's a 5-minute stop there. You may be waiting a little bit for them to process some paperwork. Okay. All right. Anything else, Mr. Tevis?
No, Judge, thank you for making the call. I've also emailed Ms. Nelson the sealing order electronically in Word format.
Great. Ms. Rutland, anything else?
No, Your Honor, thank you.
All right, look at that. It was kind of full service here today. I don't use that phone all that often. All right, hold on. Let me see if there's anything else. Nope, that was someone letting me know the sound went out. Mr. Drabeck, don't do this again.
Understood.
All right. Thank you, everyone.
Thank you.
Thank you.
Appreciate you accommodating our earlier schedule, also the state as well. Thank you. You'll have to talk to the probation.
Ms. Rivers, have a great weekend.
You too, Judge. Thank you.
All right, bye-bye. We're not going to see you for a bunch of weeks. Have a goodish break.
Yes, I will try. Yes.
All right, do your best. Keep us posted.
Okay, I definitely will.